Okay, we are coming down to the last lap for today, except for the reception. And so this panel, we sort of moved through, you know, the right to be informed, transparency, privacy, confidentiality, and now we're looking at the right to appeal to an independent forum, and in particular, the judiciary, and the role of the judiciary in protecting taxpayer rights. So I'm going to turn it over to Chief Special Trial Judge Peter Panuthos of the United States Tax Court. Take it
Nina,
away.
thank you, and thank you for having this conference. Thank you for inviting us. And it certainly does make sense that I suppose the judiciary should be here, given the issue on the list, including right to an independent forum and issues of access to justice. So if my clicker works here, which it looks like it does, my first job today is to introduce my panel. And to the my far left, your right, is Judge Tamara Ashford. And Tamara was appointed by President Obama in December of 2014, so she's a newbie on the court. But
I'm the most junior judge on the court.
with an incredible amount of experience in both private practice and particularly with the Department of Justice, holding a number of important positions. So, Tamara, lovely to have you here and to work with you. You might notice on your program that there was a gentleman whose first name was Javier, and Judge Podizek called yesterday morning with some good news and bad news. And the good news was that he had just been nominated to be a Supreme Court Justice in Mexico. And the bad news was that as a result of that and required to be in town for hearings, that he was not going to come. And we were the good news, again, is that Judge Anna Brune is here. Anna, thank you for being here. And Anna was born in Mexico City, educated in Mexico, also has a master's LLM degree from Columbia, has been a Fulbright student, scholar, and worked with the Deputy Attorney General and was appointed a magistrate judge in 2009, and I guess your appointment is good through 2019. So Anna, it's delightful to have you here, and thank you for making this last minute.
I'm very happy to.
And finally, to my immediate left here is Associate Chief Justice Lucille Amira. I've known Lucy now for a couple of years. Lucy was educated in Canada. She has been in private practice. She was also worked as a member of the Department of Justice in Montreal. And this past February, she was appointed as Associate Chief Justice of the Tax Court of Canada. One of the wonderful things about a recent organization, which is the International Association of Tax Judges, is that I've gotten to meet so many judges from around the world, an organization that was formed about 7 years ago, and with over 100 tax judges from around the world. And it's been a wonderful way for the tax judges to exchange ideas. So what we're going to do this afternoon for this panel is to ask a series of questions. But before I ask the questions, let me just, we got a blank screen. I'm also going to be pushing this button. If I can do both of these things at the same time, it'll be an incredible accomplishment. But
does it work? Oh, you got it.
I think I might need some help. So in any event, oh, here we go. So the right to appeal to an independent forum, and the question is, well, what does this mean? And the reason I ask this question is twofold. One is that I'm told at the end of the day, if you ask rhetorical questions, that people listen more. So, so I'm hoping that you'll wait for the answer. So what does this mean? It means that the forum or the reviewing court is independent of the taxing authority and fully able to impartially find facts and render opinions as to the law without interference. I see we have a blank screen there, but there's your answer. So the second issue is the question of the right to appeal, and the right to appeal means the taxpayer has been reasonably informed of the opportunity to dispute the findings and conclusions made by the taxing authority, and that taxpayers have equal access to the independent forum to dispute the findings and conclusions, and we'll be talking about access to justice. So we're going to break this panel into sort of two parts, and part one, we're going to ask a series of questions about independence of forum to our panelists, and we'll exchange ideas and have a conversation, and part two is going to be the issue of access to justice. So I think I'm prepared to go to part one is to talk about what is the appointment process and tenure of your court. So I'm going to ask Associate Chief Justice Lamar to talk about that initially, and then we'll pass it on.
So good afternoon, everyone, and thank you for having invited me here today. So in Canada, the appointment and administration of judges is governed by the Constitutions Act of 1867 and 1982 and the Judges Act. The Tax Court of Canada is a specialized court which has been created in 1983 by a federal statute, the Tax Court of Canada Act. It is a superior court of justice of 22 judges, including the Chief Justice and myself, sitting on this court, and we are governed by the Judges Act. So the qualification for appointment are set out in the Tax Court of Canada Act, and you need to be a person who is or has been a judge of a superior court, or a person who is or has been a barrister or advocate of at least 10 years standing at the bar of any province. The federal cabinet, which is composed of the members of the parliament chosen by the prime minister, receives recommendations from the Minister of Justice for puisne judge and the prime minister for the chief justice and the associate chief justices. The recommendation to cabinet is made from amongst the names which have been previously reported by committees to the minister. The cabinet advises then the Governor General, who ultimately will make the appointment at the tax court. The committees which report to the minister are independent judicial advisory committees. We call them JAC, and they constitute the heart of the appointment process. JAC are administered by the Commissioner for Federal Judicial Affairs of Canada on behalf of the minister. We have many JACs, but for the Tax Court of Canada, we have our own JAC, which is comprised of 5 members. 1 judicial nominee, who is designated by the Chief Justice of our court and is appointed by the minister, and 4 nominees of the Minister of Justice appointed to reflect Canada's linguistic and geographic diversity. There shall be at least 1 member for each of the following regions: Maritimes, Quebec, Ontario, and Western Canada. The committee chair is the judicial nominee, and the members are appointed by the federal Minister of Justice for 3-year terms with the possibility of a single renewal at the minister's discretion. The Commissioner of Federal Judicial Affairs receives the application and he administers the JACs, and then, which then assess the qualifications of the applicants. The chairman allocates the file for due diligence among the members, and each member addresses the committee its due diligence work on each file that was assigned to him and give his recommendation to the candidate. The primary qualification of judges are professional competence and overall merit, and at the tax court, a tax practitioner or a civil litigant are qualification usually required for the position. Personal characteristic and potential impediments are also considered. Then there is a vote on the JAC to accept or not the recommendation. The applicant will be recommended if it is approved by the majority, and the chair, the judge on the committee, has a tie vote. The recommendation is good for 2 years. The FGA will call the candidate and let him know or her know that his application was dealt with, but he will not tell whether it was recommended or not. If it's recommended and accepted, the minister will call the applicant and advise her or him that he was appointed. Judges are required to cease, so when you're appointed, it's for life until you're 75 years old. But you can retire, there is the rule of 80, we call it, so you can retire after a certain period of years, at least 15 years, but it depends on your age also. But you cannot stay after 75 years old. And subject to age limit, judges may hold office during good behavior and are removable by the Governor General on address of the Senate and the House of Commons. So as a whole, this is the process of the appointment of judges in Canada. So I don't know if you want to say.
Judge Brune or Judge Ashford, would you like to talk about your court's?
Sure, I'll go, and I'm sure, Judge Panuthos, you will chime in, or I'll nudge you to chime in. But let me talk, and I probably will be fairly brief on this point regarding the appointment process and tenure to be a judge on the United States Tax Court. I think I certainly have, well, very, recent exposure to it since I just went through the process, which started for me 2 years ago, but certainly by statute, and it's in our Internal Revenue Code 7443B. The president is authorized to appoint, certainly subject to U.S. Senate confirmation, 19 judges to the United States Tax Court. And I think as I mentioned, or Judge Panuthos mentioned at the outset, I'm the 17th judge, and right now there are 2 vacancies on the court, of which actually 2 individuals the President Obama has in fact nominated. He actually made a recent nomination or announcement of a nomination just a couple of weeks ago. And so those nominees are going through, I guess, somewhat maybe the torturous process of trying to get confirmed and get to the court. And so in our system, once they have been nominated, as I mentioned, it's subject to the nomination, or the appointment is subject to confirmation by the United States Senate. And so one of our Senate committees, not the Senate Judiciary Committee, but rather the Senate Finance Committee, will hold a nomination hearing with the candidate, ask the candidate questions. They could be substantive, they might not be substantive, so relating to, what's your background, what qualifies you, do you think you can be impartial to serve on the bench? And when that hearing is over, as what happened to me, I had a few what's called questions for the record, where I had to submit written answers to some written questions. And then it will be closed. And then ultimately, the Senate Finance Committee will report out, will vote on the nomination, hopefully favorably. And then when that happens, then the nomination goes to the Senate floor, where the full Senate, all 100 senators, at some point will vote on the nomination. There needs to be a majority vote for that. And the tenure, I will just add, unlike Canada though, our tenure is not unlimited. So we are, just for mostly really quite frankly for folks, non-US folks, the tax court is a court of record, is a court that was created under Article 1 of the Constitution, of the United States Constitution, as opposed to Article 3 of the United States Constitution. Article 3 judges, which are district court judges, regional circuit courts of appeals judges, and Supreme Court justices, have lifetime appointment. Courts that are Article 1, which is the tax court, as well as the United States Court of Federal Claims and some other specialized courts, have a 15-year term. So for me, I was sworn in, I'm coming up on a year now, last December, so my term will end in 2029, and quite I'm not really thinking about that, right? And hopefully, and quite frankly, I think it's the history of the court that no matter what party is in the White House, the individual, if they would like, will be or can be re-nominated. And so you would have to go through the whole process again to have another 15-year term. So I'll just cross that bridge when 2029 comes.
Thank you. First of all, I want to thank Peter, thank Nina. I was very happy to hear the news that I will be here with you today. I was much more happier to hear about Dr. Laine's nomination to the Supreme Court. And now he's having to do all the process of the committees and whatever. And that's a very important thing about our court in Mexico, is that we are an administrative court. We are not part of the judiciary, no, so we also are like other type of judges, but our appointment process is basically the same. The president makes a nomination and the Senate ratifies us, but we have to go through a procedure of all the committees, finance committees, justice committee, and as Tamara was speaking, it's Sometimes they ask you questions about why are you able to be a judge, or what are the requirements, or how are you gonna be an achiever at being a judge, or how can you help the court system in your country? And sometimes they can ask some political questions that are not really quite easy to tackle, but well, we passed through that torture. The magistrates our court, our tax court, has not only jurisdiction over tax matters, but we also have jurisdiction on several other matters, because we tend to solve the disputes between the federal administration and all the individuals. So we get to know environmental law, we have to know also property rights law, liability, pensions. So we are like quite general, and we are like a federal court, so we just have to decide against for the claims that are presented by any individual that has been whose teams that has been their rights being violated by the federal government. So it's quite some very important thing that we get to see many types of claims. We have a superior chamber and regional chambers. There are 50 regional chambers throughout the country, and we have 6 specialized chambers. So that's the way that we are organized. Well, I believe basically covers
Thank
it.
And one thing I was gonna say, I would be remiss and Judge, or Peter, if you would, or Judge Benitez, if you would.
Whatever.
If you would talk about, because I certainly was talking about the presidential appointment
Surely,
process.
so just
so there's a cadre of special trial judges, of which Judge Benitez is the chief of. So
right.
have you talk about that?
So the
very
special
briefly.
trial judges are appointed by the court, not political appointees, and they're very much akin to the U.S. magistrate judges of the U.S. District Court. So, for example, I was appointed to the U.S. Tax Court sometime after the enactment of the Internal Revenue Code of 1954, but before the Restructuring Act of 1998.
Okay.
And in fact, if you split that difference and added 7, you'd find out the year that I was appointed. So
You all do the math.
so the next question I'm going to ask Anna to start us off here is, and we may have already covered this a little bit, but let's just fill in any blanks. So what's the relationship of your court with other parts of the government, both the executive and the legislative branches?
Thank you. As I already said, the Mexican Administrative Court has jurisdiction over every matter regarding the federal administration and the individual. We are part of the executive branch, but we are independent from the executive branch. And the idea of that independence is very important, because since we are a part of the executive branch, we need this budgetary autonomy, or the fixed terms that our magistrates have in order to feel free and in liberty to dictate our resolutions. So I was saying we have fixed terms that gives us autonomy for the executive. We have budgetary autonomy. That's very important, because before, our budget was controlled by the Ministry of Finance. So imagine, how can a court be independent or autonomous if the budget is controlled by the Ministry of Finance, that usually goes to trial to your court? So we've worked very hard to have this independence, and this year we had a very important constitutional amendment that gave us this constitutional autonomy and this budgetary autonomy. So now the Congress passes our budget, of course, but now that we have the budget, we can decide how to manage the budget. So, as they say, one who controls the money can have like very much freedom and liberty to dictate the resolutions. As well, we have administrative independence. That means that our procedures are strict procedures, strict law procedures, and there is no way they can, the executive or the offices can tell us how can we rule or how can we decide the rulings. I believe
Okay, thank you.
that covers.
Lucy, do you want to add anything?
Oh, yes, well, in Canada, the executive branch, it's the Prime Minister, the ministers, the public service, and other organizations, and they administer and enforce the laws in place. The legislature, the parliament, makes, alters, and repeals the law. And the judiciary, the courts, is one independent branch of the government. It resolves disputes according to law. The Tax Court of Canada is independent from the Canada Revenue Agency and other government organizations. As a matter of fact, the CRA is always one party before the court, but we're independent. We're paid by the government, the judges, but we're independent from the CRA. And there is no interference with how the tax court manages the legal process and exercises its judicial functions. We have several institutions that's worked to support the judicial independence and to keep the judiciary separate in areas like discipline, compensation, and continuing education.
And I'll just answer the question, well, by saying a couple of things. One, I would say, well, we have no relationship to, well, both the legislative and executive branches, although I will caveat that by saying a couple of things. One, which I just mentioned with respect to the legislative branch, that they, have control, they, by statute, confirm nominees to the court. And I also say the legislature provides the tax court's funding. And then certainly with respect to the executive branch, as I mentioned, again, pursuant to statute, the president has the authority to appoint individuals to the court, as well as also does have, again, by statute, removal power of someone that's presidentially appointed, like myself, subject to notice and hearing. That's all I'll say on that, I think, for the moment. I think folks in the, well, I know folks in the audience, I will just raise that this issue of, is the tax court, what branch of the government is the tax court a part of, recently has been raised in the context of some cases. And I will, let me back up by saying, so there certainly is an old or somewhat old 1991 United States Supreme Court case. Most of the folks that are U.S. tax practitioners are fully aware of this case, which is Freitag v. Commissioner. And certainly in that case, the Supreme Court held that the tax court is independent of the legislative and executive branches. And so more recently, there certainly has been some questions or issues raised relating to, as a result of Freitag and with the president's appointment and removal power, that violates separation of powers. And more recently, one of our regional circuit courts of appeals, which the U.S. Court of Appeals for the D.C. Circuit had ruled, I guess for constitutional purposes, the tax court is a part of the executive branch. But I won't say, there are other cases that are pending before the tax court, and so I won't comment any further on the wisdom of that case.
Thank you, Judge Ashford, for handling that question so delicately. And so I think we've already talked a little bit about this, but this sort of part two of this of question 3 is how does the court respond to reviewing or higher courts? So maybe we could talk about that for a bit.
Sure. I guess that is to me. So I will just say, with respect to the U.S. system and the U.S. tax court, as I mentioned at the outset, the tax court is a specialized trial court. We function the same way as what's called our United States district courts, but we sit without a jury. And then again, for those that are non-U.S. people, the way our tax system is set up, a taxpayer can dispute what tax the IRS alleges he or she owes, there's two forums. One route is going to our U.S. District Court route, which does actually afford the taxpayer to decide his case with a jury of his peers. But to get to that court, the taxpayer would actually have to pay the proposed tax first and then sue the government for a refund. Obviously, for a taxpayer that maybe has limited financial means, that would be very difficult to get to get to that forum. And so, hence the creation of our court. What I sort of like to say, and I think Peter would probably agree, I think many people look at the United States Tax Court as the people's court. We are the only, I guess, we certainly are unique in the federal system in that we're the only prepayment forum. And so a taxpayer, all they have to do is pay the $60 filing fee, and they are in our court. And then just in terms of, very quickly, in terms of reviewing, how does our court respond to reviewing higher courts? So I probably mentioned this a little bit, or certainly alluded to it. Our cases, are appealable to, just like as with the district courts or the Court of Federal Claims, are appealable to the regional courts of appeals. So to the U.S. Courts of Appeals for the circuit in which is located the taxpayer's taxpayer's residence or the taxpayer's principal place of business. So for example, if a taxpayer lived in Boston and filed a tax court petition, if they wanted to appeal the decision of the tax court, they would appeal to the United States Court of Appeals for the First Circuit. There are actually 13 circuits. And then, of course, ultimately, perhaps they might have redress to the Supreme Court. And then my one other point on this question would just be when Peter and I are considering issues in a particular case, we are bound to follow the law of the circuit in which the case is appealable. In U.S. tax parlance, that's known as the Golson Rule, which is an old, actually 1970 case, Golson v. Commissioner, which set forth that proposition, and I think was affirmed on appeal by the United States Court of Appeals for the 10th Circuit.
Okay, as I said before, our court is not part of the judiciary, but it's part of the executive, and we do have independence and autonomy. However, the judiciary branch is in charge of reviewing our resolutions. So the system works like this. When the tax agency resolves that a taxpayer has not complied to his obligations or her obligations, that resolution may be contested through two procedures. First, directly to the tax agency, who will review the resolution and that can confirm, modify, or annul the resolution, or presents its claim directly to the tax court. The taxpayers, through the Mexican habeas corpus called the Amparo, may appeal the decisions that we take to the judiciary. So the judiciary, composed of regional tribunals as well, courts, will review our resolutions and also decide if it's confirmed, revoked, or annulled. No? Okay, the decisions of the judiciary, the regional tribunals, can be held or known by the Supreme Court, like a type of certiorari petition. Mm-hmm. So only if the aspect at hand is very relevant, the Supreme Court may review the procedure. So we have cases that are reviewed, our decisions are reviewed by the Mexican Supreme Court, and that's really something great when we have a confirmation from the Supreme Court about one of our
Now, does
decisions.
the Mexican Supreme Court, do they review or hear many tax cases?
Yes, they do.
Oh, okay.
Yes.
That
a
would
lot.
be unlike the U.S. system.
And actually, no, the case law that the Supreme Court's made, it's very important for us in Mexico because the Supreme Court has taking a lot of very important steps in protecting human rights and specifically taxpayers' rights. So it's the case law on taxpayers' rights. It's quite great. So that's about the system.
Thank you, Anna. Lucy?
In Canada, as I said before, the Tax Court of Canada is specialized and deals with matters that are defined under the Tax Court of Canada Act, including the Income Tax Act, the GST, and other matters. So the court deals with disputes between the federal government and taxpayers concerning federal tax and revenue legislation. So when the taxpayer is assessed, the first level of objection is before the Canada Revenue Agency. And then if the assessment is confirmed by the Canada Revenue Agency, then the taxpayer may appeal before our court. And then our decision may be appealed before the Federal Court, the Federal Court of Appeal, which is at the federal level, and then to the Supreme Court of Canada. And the Supreme Court of Canada hears what it considers to be of public importance and to have national significance, and they have precedential value. So before you ask me the question, not very much of our decision go to the Supreme Court of Canada, because I don't think they think that we are of a national significance. So most of the decisions end at the level of the Federal Court of Appeal. And for the provincial level, each province deals with their own taxes, so they have their own courts to deal with the provincial taxes. So at the tax court, it's really the federal level.
Justice Lamar, I know that your court has a procedure which you call the informal procedure, and the U.S. Tax Court has a small case procedure. And in our court, those cases are not subject to appeal. In other words, the decision entered by the judge in the tax court is final. And how does that work for the informal procedure in the Canadian tax court?
The informal procedures is accessible for taxpayers who are contesting or opposing an assessment under $25,000 a year. And when we render a decision under the informal procedure, they have the right to appeal right away to the Court of Appeal, and in fact, it happens very often.
Thank you. So the next question, and it may be that this will be easy, but maybe not. So are there any pressures, given that we're talking here about independence of the judiciary? I thought it was important to throw this question in to see if there are any particular pressures on the courts with respect to either from the enforcement agency or the public or any other source in terms of the court's independence.
So it's my turn again. So the tax court, as I said before, is independent of the CRA. This is very important because when the taxpayer come before us, they're looking at you and say, you have everything. We gave you already everything. And I have to say, no, I don't have anything in front of me. So we're separate from the CRA and the other government. Judicial independence is the cornerstone of the Canadian judicial system. That is why under the Constitution, the judiciary is separate from and independent of the other two branches of the government, as I said before, the executive and the legislature. Judicial independence guarantees that judges will be able to make decisions free of influence and based solely on fact and on law. As was mentioned by the Chief Justice of our Supreme Court of Canada, we enjoy a judicial system that is honest. I hope so. Influence and bribery find apparently no place in our judicial institution. Our lawyers and law societies observe the highest standard of ethic conduct. This is what Beverly McLaughlin said. So we have independent, impartial judges who are not influenced by parties or politicians. So to the Canadian government, the principle of judicial independence has three components. The first one is the security of tenure that I addressed earlier. The judges can stay until he is 75 years old. The second principle is the financial security. Judges must be guaranteed sufficient compensation, including salary and pension. I must tell you that my spouse is a doctor and is very jealous of my remuneration. So that we are not subject to any pressure for financial considerations. In Canada, governments cannot change judges' salaries or benefits without first receiving recommendation of an independent compensation commission. Third, the administrative independence. As part of Canada's commitment, no one can interfere with how courts manage the legal process and exercise their judicial function. For example, only the Chief Justice can choose how cases are assigned to the judges of his or her court. And we have several institutions, and they have been established to support judicial independence. These include, first, the Canadian Judicial Council, which consists of the Chief Justice and Associate Chief Justice of all the federal courts and provincial and territorial superior courts. And the CJC promotes efficiency, consistency, and quality judicial service in these courts. One of the CJC's tasks is to investigate complaints and allegations of misconduct of federally appointed judges. The CJC has also developed a set of ethical principles for judges to help judges ensure that they maintain their independence, integrity, and impartiality. We also have the Commissioner for Judicial Affairs, which administers the pay and benefits for the judges, and also, as addressed earlier, they administer the Advisory Committee, the JAC, representing each province and territory for federal judicial appointments. Then we have the National Judicial Institute, which delivers educational programs for the judges on all aspects of judging, as well as specific substantive areas of the law. The institute is funded by each level of government and regularly offers courses for new judges, effective judgment writing, detailed instructions in new areas of the law. And finally, we have the Courts Administration Services, which administers the court. So they take charge of the procurement, the facilities, and all the budget required for the functioning of the courts. So in the end, maintaining the quality of our justice system depends on preserving honest, independent courts, well-trained judges and lawyers, efficient procedures, and a new sense of justice. And above all, by treating the public we serve with the respect and dignity to which each human being is entitled. Thank you.
Yes, thank you, Mark. Anybody want to?
Yes, I would definitely answer the question, no, no. Although we are part of the executive, we have remained very autonomous. And as I said before, the late amendments to the Constitution have given us constitutional autonomy. For an administrative tribunal to have constitutional autonomy is quite important. We are the only administrative tribunal to have this constitutional autonomy, so it's really relevant. As well, we have security tenure. No, we don't have removal. The president does not have removal, so the executive and the Senate appoint us. But to remove a judge from the seat, although we have fixed terms of 10 or 15 years, but it's very difficult to remove a judge. No?
Although I will say, in the history of the court, the president has never used the removal power.
But
So-
he has it still.
But he does have it, yes.
In Mexico, no, we have the tenure, so that's also important. And we have administrative independence, so that we have strict rules on how we manage the legal process. For instance, the cases are randomly assigned to each magistrate by a computerized system. So it's not like it's your turn, no, it's random. So that's also really, really important. And
Good. Thank you, Anna. Judge
Well, I
Ashby,
can
you want to
answer
say
it very
anything?
briefly.
Yeah.
No. How about that? Do you have anything to
Great,
add?
and let me just add, let me just add to that. So I think that the point that's been made by our other judges is how cases get assigned, and also the geographic diversity of our court. I think that's really been important, so that it's not like there's a resident judge in Chicago who gets to even particularly friendly know whether it be the government folks, whether it be the private bar, so that we don't, and in the same way it is with issues. So the way sessions get assigned is that when there are enough cases for a particular city, the court sits in 3 terms, and the chief judge sits down, and judges sort of bid for different cities, and the chief judge makes these assignments well in advance, but the judges generally travel to 74 cities throughout the United States, so they're not necessarily coming back to the same place all the time, and those assignments and the assignment of cases, whether they be special assignments of big cases or whatever, have nothing to do with any relationship other than let's get a judge to handle a matter, and it's just a totally independent decision. So just to finalize this question about independence of the judiciary, the final question, and it may be that we'd have nothing else to talk about, is does the current government system provide sufficient independence for the tax court, and do you believe there's a need for changes in the current system? And it's fine if you all say it's perfect, and we can go on to the next section, or whatever.
Yes and no?
Yes and no. Yes, okay, of course, yes, the current government system provides that independence for the tax court, but I believe that a possible change that will benefit and be very beneficial is the implementation of a civil service career or a judicial career inside our tribunal. That would be very important because in the judiciary in 1996, the judicial career was implemented, and today, almost 20 years later, we can see the benefits of having judges that have served as clerks, judicial officers, before being appointed judges or magistrates. In the judiciary, the judges are only appointed after many years of experience in the judicial career and after passing examination. So the judges of the judiciary are not appointed by the president or conferred by the Senate. They are appointed because they made a judicial career, and they, from the lower levels, they were going up, and finally they could be judges after a careful examination of their careers. I really believe that the experience of the judiciary will be very, very beneficial for our tax court. That way, we will guarantee magistrates with fully appointed merits and not a political convenience that sometimes can happen while appointing magistrates. So that's.
Thank you.
I just want to say in Canada, I think there is sufficient independence of, as several checks and balances are in place, but it is suggested some improvements may be made to the judicial appointment process, such as having more transparency in the judicial appointment process through the announcement of potential vacancies, through the providing more guidance on the process of appointment, and through encouraging application from individuals of diverse backgrounds to ensure the court is representative of the Canadian population. But in the whole, I think we have a fair system. It's not perfect, but there is always place for improvement.
Great, thank you. Anything else on that?
I don't think,
Oh.
do you have anything to add?
Okay, I think we're there. So I think let's get to part two of this presentation. I think what I consider to be, the second leg and as important as anything else, which is, so it's one thing to have an independent judiciary, but if you don't have access to the court, then it doesn't really serve any great purpose. So the first, and what I note is that for those of us in the United States, that we pretty much know that in 1981, the Supreme Court of the United States ruled in a case, Lassiter v. Department of Social Services, that there was no constitutional right to counsel in a civil case. A number of things have happened to try to fill in that gap, but that's sort of where we stand in the United States. So let's talk about what the tribunals are doing to try to assist taxpayers.
Yeah, so I think from the U.S. perspective, my court or our court has taken a host of steps, I think, to accommodate taxpayers. The first step that I'll talk about, which I think is certainly worthy of talking about, is we have a very, I would say, user-friendly website. Actually, I would encourage folks that have not gone onto the website, www.ustaxcourt.gov. It provides a wealth of information for the taxpayer. Before they begin their case, during the case, and after. And so, in fact, if you actually went to the website, there is a link or a tab called Taxpayer Information. If you click on that, then there are several sub-tabs that have various topics and that set forth information in a very nice sort of layman's, question and answer format, really a nice step-by-step guide for the taxpayer. So that provides an introduction to the court, that provides sort of a question and answers regarding about the court, starting a case, before trial, during trial, after trial. There actually is a whole section that's titled Glossary of Terms. So, these are, things where an unsophisticated or certainly self-represented taxpayer, they may not understand, what's a motion for summary judgment, or really, an answer, a motion to dismiss, what do those things mean? And then there also is a very nice video on the website, which I think sort of has a mock trial of the tax court. And so in fact, if you actually went on the website and printed up all those pages, it would be, it would be this. I printed it up. It would be this thick. And I do have to give a nod to Judge Panuthos, because I think you are responsible for the production of the video and also having the whole electronic guide for a taxpayer.
Thank you, Judge Ashford. And the history of that was that about 20 some odd years ago, we actually produced a video. I flew to Los Angeles and we made a video, and I was the judge actor. When I
You played it well.
When I came back, the then Chief Judge, Mary Ann Cohn, who's a good friend, reminded me that I should not give up my day job after trying to pretend that I was a judge on the video. And in any event, as things developed, the video went out of date, and then, of course, as we all got rid of our VCRs in any event, so that we then updated it, and we now have a streaming, whatever you'd call it.
Sort of, it's almost like it's the tax court YouTube video.
But and we did hire professional actors, and thank
Right.
goodness I was off the screen at that point.
But other steps I'll also mention, and certainly feel free, Peter, to chime in. Well, in addition to the website, certainly on the website, we actually have for a taxpayer a fillable petition or complaint. So, they don't have to, quite frankly, worry about, am I using the correct language? It's all there for the taxpayer. In addition, Peter had mentioned at the outset, the taxpayer can what's called elect S case or small case status, which is for cases that the amount at issue is less than $50,000. And if a taxpayer elects that status, then part of the conditions or rules, which is, I think, great for the taxpayers, that ordinarily in regular cases, the court follows the federal rules of evidence. But if a taxpayer elects S case status, then the rules of evidence are relaxed. And so, quite frankly, any evidence that's relevant can come in, can be admitted as a part of the record. Although, of course, as Peter had mentioned, the flip side to that is by electing S status, that neither the government nor the taxpayer can take an appeal from that. Other steps that the court has taken to accommodate taxpayers is that, so we, and Peter again had mentioned this, we go to the taxpayer. So we sit in 74 different cities across the country. I think instead of making taxpayers incur an expense and travel to Washington, D.C. I think probably another very important step is that it's on the website, and it also gets sent out about 6 months before a taxpayer's trial actually occurs. Is a taxpayer, and I certainly have it right here, we have a nice handy-dandy list of low-income taxpayer clinics and pro bono counsel, so that the taxpayer on their own can search out and get advice, or maybe even have free representation. And so certainly for me, and I know Peter does this, and I think many of my colleagues do this, literally at the session, the first day of the trial session, in my introductory remarks, I try to explain to all the taxpayers that are in the room, what's going to happen, what does it mean for your case to be called, what's the calendar call, and what does the session look like. And I will also introduce, usually at every session, there is pro bono counsel or a low-income taxpayer clinic, sometimes more than one, there to provide assistance to the taxpayer. And so I always make sure to announce that, to let the taxpayer know that these individuals are here in the courtroom, and then when their case is called, they can certainly, if they want to speak with pro bono counsel or low-income, the taxpayer clinic, they can do so, and then I will recall their case. I think they certainly, so I think there's over 105 low-income taxpayer clinics, and certainly we have great calendar call programs, I think in more than 25 cities.
That's right. That's right.
I know I've said a
So
lot.
let's talk about Canada and Mexico and see how that maybe differs.
We too have our movie, but we didn't go to Hollywood to do that.
Yeah.
We asked one judge of our court to ask us, actually he's retired now, but he did that. And we asked person of the court to play the litigants and the Crown Counsel and the registrar. So it's quite interesting, and it's posted on the website of our court, and it's entitled Your Day in Court. And it explains how the litigant might get ready to come to court, because it's a bit, they're a bit anxious when they're coming before us. So we have, on that video, we have also a text, not just the video, and we say that in that text who the participants are, like when they're going to come to court, who is going to be there, when to arrive at the hearing, how to behave, the process of the hearing, and there is a checklist for the litigant with all the steps involved. The court also made available links to information that includes deadlines and procedure to request an extension of time to file an appeal, the procedures depending on the nature of the appeal, and the information about the court's registry and services. There are also links to relevant statutes, practice notes to assist on the application of the court's rules, and the court forms. We also, as we said before, we have the informal procedure, which is intended to enhance access to the court where small amount of money are at issue, if small is under $25,000. And we have more relaxed rule. We create flexible, efficient, and expedient process. We too are a circuit court. We travel across Canada. We go to approximately 60 cities, and we sit in courthouse, hotel, conference room, rectories. We even sat in a taxpayer's kitchen.
We don't sit in a hotel.
We sit in hotels and even taxpayers' kitchen when they cannot move. So, so we're really flexible, and we try to help them. I'll speak of pro bono later on because
Some of our judges have actually gone and held hearings or trials in jail. So So.
So
Anna, do you wanna-
Yes, we don't have videos.
Okay.
We don't have videos because we are a civil law system, so our hearings, our trials are written in manner. We don't have oral procedures in the tax matters. We are starting to have oral procedures in the criminal matters, but not in the tax or administrative matters. So, but we are taking steps to help taxpayers, and actually the Mexican Supreme Court recently ruled that the Constitution compels all Mexican courts to take into account international agreements on human rights in the rulings. So if there's a contradiction between our internal laws or statutes and an international agreement, we must give preference to international agreement on human rights. This allows judges to focus on substantive law rather than procedural features or strict features. And also a very important step has been the creation of the PRODECON, the Taxpayer Advocate Office, and here we have the Taxpayer Advocate. So I won't go too much detail because you'll be able to hear her tomorrow. But the PRODECON is an organism committed to develop a non-judicial review over the decisions, actions, or resolution of any government agency or public organism which collects taxes or any other kind of duties. And its main attributions are advise and counsel taxpayers regarding rights and obligation, give taxpayers legal defense, process complaints and pronounce public recommendations, propose amendments to tax regulations, and analyze systemic tax problems and offer corrective solutions. These attributions empower PRODECON as a public taxpayers intercessors. So the creation of this organism has been very important for taxpayer rights.
So, Anna, does that mean that the taxpayer advocate will actually represent taxpayers in court if they ask
Yes.
for that assistance?
Yes, if the legal claim, I believe, is under $50,000, they will represent more or less. They will represent taxpayers, but also they will give legal counsel to any taxpayer, big enterprise, small enterprise. They provide legal counsel, so it's quite important, the creation of the PRODECON.
So I think the next question that really follows up from this, which is what's our job as judges when someone is pro se representing themselves? Can we remain impartial if we're trying to assist a taxpayer?
Okay, that's a very important question because the question is where to draw the line between assistance to ensure a fair trial for the SRLs and the assistance that results in improper bias, in her favor. So the thing is, like in our country, in Mexico, it's extremely difficult for taxpayers to go to courts to be self-represented. Our trial procedures are written in manner, as I say, and it makes very difficult for the taxpayer to present finer points of their complaint without the help of a tax advocate, attorney. The nice thing here is that Mexican judges, we are obliged to apply the law and observe the case law and the jurisprudence, but in Mexico we have a very nice principle that the judge is entitled to take any step necessary to better resolve the controversy. So we may, for example, ask questions of clarification. We may call attention to omissions in evidence. We can correct defects in failure to cite correct legal theory and look beyond the label of the document. We have a principle that says, give me the facts and I'll give you the law. So if they put on the facts, the judge will give the law.
So hypothetically, I think you talked earlier today about the fact that much of your work is on the written record.
Yes.
So if the written record is not complete, not understandable, or doesn't sort of fit into the law, can you then go back to the taxpayer and say, in order for me to decide this case, I need to have something more?
Yes, we may request evidence, any type of documents related to the facts. So that's very important, and we can ask any authority if they have the documents. We can order that authority to give that documents to us, because sometimes the taxpayer goes to the authority and they do not provide the documents they need to present to the court. So we may be able to ask for those evidence. We can order and practice judicial proceedings, ask for experts' opinions, even though the taxpayer has not presented expert opinion over the documents and the facts. We may ask to do so. So that's very important as well in order to provide taxpayers with.
And just curious, how does that operate in terms of, do you issue an order to the parties and say, I'm ordering that the taxpayer do thus and so, or provide further information?
Yeah, usually we order the authorities, because the authorities have all the documents. When there's a resolution to the taxpayer, the authority have this very big series of documents that have in his possession, and or other authorities, finance authorities, or the banks or whatever. So we request the specific authority or the bank or whatever to give us those documents, checks, statements, all of that.
Thank you. I think we're going to probably have some differences here. So.
Okay, in Canada, the most important concern when assisting self-representing taxpayers is maintaining neutrality and avoiding an apprehension of bias. Sorry. In Canada, we have the adversarial system of determining legal disputes. So the courts rely on the parties to frame the issues and assign the courts the role of neutral arbiter. So to ensure that judges remain independent and impartial and are seen to remain independent and impartial. When the judge intervenes, the risk is to create an apprehension of bias. He must not give the impression that his mind is already made up. So on the other hand, courts also have the role of ensuring that, that justice is done. So to find out the truth and to do justice, judges sometimes must intervene. The question then is how to strike the appropriate balance between these competing principles. My former Chief Justice Bowman, in a case, he said, "We judges are something more than a mere referee in a boxing match, but we are not continental inquisitors either." And he said, in another case, "While I believe that where a litigant is unrepresented, it is permissible for the trial judge to intervene more than he might where counsel are involved, there are limits." The Federal Court of Appeal allowed in some cases an appeal and ordered a new trial when the trial judge intervened so excessively that he appeared to have taken on the role of counsel. In Mian, a very recent case of the Supreme Court of Canada, the court said, "The court can intervene to assist a self-represented litigant to ensure that the proceedings are fair, although this assistance has neutrality-based limits, and a judge must exercise great care not to descend from the bench and become a specter at the accused counsel table, placing himself in the impossible position of being both advocate and impartial arbiter." So we have to be very careful. We may assist the taxpayers, but at the same time, we cannot act as the advocate for the taxpayer.
Yeah, I think certainly from the U.S. perspective, I mean, our philosophy is probably much more akin to yours, Judge Lamar. Certainly, I will say that, our job, is to find the facts and resolve, the issues, what they are, sort of based on what the applicable law is. I think certainly I've only been on the court for a year, and I've already, I've seen many times, taxpayers will come, before me, and they have never, been involved or been to tax court, let alone a court at all. And so while, I talked very, highly of our website and all the guidance that it provides to a taxpayer in terms of how to, present their case, it still is a different matter when, they actually appear, before me and are kind of sort of, I see sort of the deer in the headlights, phenomenon. And, they don't exactly know, how they should, present their case to me. And so, in that respect, I think it's important, so that I can find the facts and make some sort of ruling, to elicit, testimony from the taxpayers. And so in that respect, when the taxpayer, him or herself, is on the stand, and I do see that they may be, having some trouble essentially, telling their story. That's what I tell taxpayers to do. It's like, tell me your story. Why do you think that, you should be able to claim these expenses, or you didn't have unreported income? And if certainly they look to be struggling, my philosophy is to intervene somewhat and start, asking questions, and maybe also reminding the taxpayer, does he or she have any, additional documents that you would like me to look at, so I can, decide your case fairly. But I think certainly, we would probably all agree that it is a fine line.
Certainly is, and I think one important distinction, of course, from what Anna's talked about in Mexico, but more similar in the Canadian, the U.S. courts, is that we are a court that relies on a record which gets closed at the end of a trial. So it becomes even more important for the judicial officer to try to, without crossing that line, to assist the taxpayer in making the record. And as many times as I've said that in my life, I'm not sure, I can still tell you that there's still a whole lot of cases out there where the record was not complete. And on a rare occasion, someone can come back later, but it does require a motion to reopen the record. There's got to be good cause for reopening the record. But I think that none of us as judges like to decide a case on an insufficient record. It's just incredibly frustrating to recognizing that it's generally the burden of proof is on the taxpayer, and that you're deciding the case against the taxpayer only because the taxpayer didn't fully develop the record. So I like the system in Mexico in the sense that after you've gotten there, you could, oh, well, let's get some more information and fill in some of the blanks here. You know, I think in the U.S. and Canada, we really can't do that.
Although I guess I
under
have
current
on a
system.
couple of occasions, and you and I have talked, and actually I've had this, recently in a couple of cases where, well, two scenarios. One, the taxpayer is on the stand and then starts referring to some documents that he or she has, at the counsel's table, and IRS counsel has not seen the documents. The taxpayer didn't really realize that he needed to have exchanged them with IRS counsel. Sort of the second scenario is taxpayers on the stand and sort of refers to documents that he claims to have but didn't bring to court. And so on a couple of occasions, I have the trial ended, and I held the evidentiary record open for 30 days, to allow the taxpayer to turn over whatever he wanted to turn over, to IRS counsel, with the thought that maybe they could then come to an agreement as to the authenticity of the documents and submit to me a supplemental stipulation of facts. So out of fairness and completeness.
With my experience, it's very rare that the taxpayer will come back with a document that, it's very usually we have a lot of floods, or fires, or they all disappear.
You've got a lot of experience on this side of the table, Tamara, and I think it's really well intended, but the problem is just, I think, as Justice Lamar said, and the other problem is that then the parties end up disagreeing about the efficacy of that document, admissibility of that document, and given a traveling court, you can't bring them in and say, well, okay, let's talk about this and get this in the record properly or not, or get the testimony that would substitute for the document, and you end up with this sort of a bit of a mess. And I've had a few of those, but I wish you the best of luck.
Thank you.
So I've just got a signal that we had 5 minutes left. For some reason, I thought we were going till 5:30, but I guess it's 5:30? Yeah, 5:15. Could somebody tell me that? I was thinking it was, and I'm fine if it's 5:15, but I was thinking it was 5:30. I don't want to. Oh, okay. All right, great. All right, so that gives us about 10 more minutes, and I think we're good. So I think the next question that I had on my list here, and we've probably already covered some of this, so we can move on and we can take time for questions or move on. What measures can or should the courts take to provide counsel to self-represented petitioners? I think that Judge Ashford has already talked about that some in terms of the clinics and calendar call program that we've got at the court. Is there anything else that we want to say about that?
We at the court, we have management, we have a status hearing, pretrial management and settlement conference, and they play vital roles. And at these pretrial conference, the judge may explain the potential consequences of not having legal advice. For example, self-represented litigant may not be aware of practices and procedure, may be unfamiliar with case law, may be unclear about what is not and is legally relevant, and the judge will suggest sometimes to go and observe cases. For informal procedure, it's different because we don't have, the case is already fixed when they're coming before us, and if we're trying to explain at the beginning of the hearing what's their case and what they have to deal with. We also tax people in need. We have a legal aid and pro bono services. But pro bono services, it's very difficult to get because the lawyers are not very available for that. And in our court, we try to help the pro bono, but we are not going to feed them and let them know. We're going to not create case sittings for pro bono. They have to come and find out the cases they may represent and try to deal with that. And for legal aid, as the Chief Justice of the Supreme Court said, it should be treated in Canada as education and health is treated. It's not enough promoted. So this is what I had to say on that, and I may, if we're in a rush, I may.
Okay, Anna,
Yeah.
did you want to?
I just want to add that I truly believe that with the creation of the Tax Advocate Office, SRLs are finally finding accessible legal counsel and legal representation. Recently, there was a tax reform, and last year, and we have this very nice instrument called conclusive agreements, and here tomorrow, I believe that, or the day after tomorrow, we'll have the tax advocate tell us about that. But the conclusive agreements are the first alternative tax dispute resolution mechanism in Mexico. So that allow the tax agency and the taxpayer to sit and agree on the assessment of the facts and omissions identified by the tax agency during an inspection procedure. So that's very important. They cannot modify the structural elements of the tariff, but it's important to have the taxpayer and the tax agency sit and speak about the facts, so before going to court. And I believe these conclusive agreements are having excellent results and will have better results in Mexico to facilitate the SRLs.
I think the last question we're probably going to get to today, and it's probably an area, again, that probably should have been earlier on, given judicial ethics, what, maybe is a question we should have had right up front, is what, what at least in your various jurisdictions, what do the code of ethics say about assistance by the judge? Do you want to take that, Tamara?
Sure, I'll be brief since we are running out of time. So our judicial code of conduct has 5 canons, and certainly the theme throughout those reiterates the importance of a judge, to remain impartial, have there be no appearance of bias, to always perform his or her duties of the office, fairly, impartially, and diligently. One of the other canons, I think it's Canon 3A4, does also say, though, that a judge should afford or accord every person who appears before him or her the full right to be heard. And so I think, I kind of grab onto that language as not being a limiting factor of the ability of a judge to assist. Again, as we kind of talked about, there is sort of a fine line, but to assist at least in creating as much as possible sort of a perfect record with respect to the self-represented taxpayer.
Thank you. So I think as we close the last 2 questions, and it really goes back to sort of the theme of the entire conference, which is what measures has your court taken to promote voluntary compliance, and what are the sources of taxpayer rights from the viewpoint of the judiciary. So I'm going to give anybody an opportunity to make some closing comments here about that, and if we have a minute or 2, we'll take a couple questions.
Well, in Canada, we don't, the tax court doesn't have any role in that, but the CRA has a voluntary disclosure program under which individuals may correct inaccurate or incomplete information. And it allows individuals to make a voluntary disclosure to protect against significant penalties or, in extreme case, prosecution that may result if the errors or omission are detected by the authorities first. So if they want to disclose their tax return, they might do that, and they will be able not to pay any penalty or prosecution. So this is a program with the Canada Revenue Agency. And it may be appeal also. If you find that the I don't know how you call it, if it was not, you have a federal court judicial review on the VDP program also. So this is it.
And I guess I'll just chime in to say that, I kind of read that question as, and Peter and I were discussing this over the past few days, that, I think, the court, speaks through its opinions, its reports and orders. Hopefully, taxpayers will, review those, our published decisions, and it will, encourage and promote voluntary compliance. I also will just say, as an aside, there have been, well, just anecdotally, there have been a couple of, instances, particularly, again, for the year that I've been on the court, in the context of CDP cases, so collection due process cases, where, the taxpayer really, would just like to resolve their matters, but, unfortunately, the appeals officer may have rejected the offer in compromise or installment agreement because the taxpayer is not, in filing compliance. And so I have on a couple of occasions, quite frankly, based on sort of the testimony that's come out, to kind of informally, on the record, counsel the taxpayer, to get in compliance. And if he or she, does that, to maybe, go to the low-income taxpayer clinic or pro bono counsel, and they might be able to work with you to fully resolving, all years of the taxpayer. And because I may only have jurisdiction over, a couple of those years, so.
Let me just, add to that, the question 6 of what are the sources of taxpayer rights, it seems to me they're certainly based in the Internal Revenue Code, they're based in our rules, and then, what we say in opinions about the Internal Revenue Code and the rules. And more importantly, it seems to me in question 5 is what have we done? I'd like to think that what we've talked about today, and not only here in this panel, but in prior panels, and that is that if taxpayers come to the tax court, have some sense that they got a fair hearing, even if they don't win entirely, even if that the system, has given them an opportunity to speak. And I think that those of us who've been around a while have seen those cases where taxpayers who have even lost have come back and say, thank you for letting me tell my story. I'm not sure what more we can do beyond that to be good listeners. Okay. Anything else from our panel? Nina, tell me if we have time for a question, and if not, I'm really fine to close this up. Oh, wonderful. Okay. We'll take any questions if anybody's got one. Diana.
Hi. You talked a lot about taxpayer rights, and the assumption I think I heard were taxpayers without disabilities. But with taxpayers with disabilities, can you talk a little bit about how your courts might address that? I'll give you 2 examples. Taxpayer comes in, shows up pro se, and says, I'm sight impaired, I need everything in Braille. Or comes in with a therapy dog and says, I need this therapy dog to sit on my lap while I give testimony. Have you guys thought about the new world of people with disabilities?
You can. Yes.
Yeah, yes, we've thought about it, and I think we've taken this on a case-by-case basis. That's about the best that I can do, Diana, and I probably an area that we need to do some more with our website on. I know certainly that we now travel, and our judges travel with hearing impaired devices, so that if a litigant indicates that they're hearing impaired, we'll provide the electronic devices, assuming that those are usable. I have not had the comfort dog issue, but I would make sure that the U.S. Marshals would allow the dog inside the courtroom. But it's a good question, and I think we probably need to do more on our website.
No, I think we definitely are thinking about it. In fact, just again, I have had a case relating to dealing with a disabled taxpayer who was he was completely deaf, and we arranged for there to be, I think it's called CARD, which was he would a computer was set up, and my talking and opposing counsel were talking would the oral would go through the computer, so it's basically, and so he would be able to read what was going on. Yes, was there, that caused some delay, but I think it worked very well. And then certainly, I don't know, just from a language standpoint, right now under our rules, we, the litigants are required to provide interpreters. Although in Los Angeles, we always do have a Spanish language interpreter.
Anything else you all wanted to say there? One more question?
Let's
Yes.
assume the American taxpayer's disability is the fact that he or she lives in Singapore. Are there procedures before the U.S. tax court in which you will rule in the absence of the taxpayer if he or she is legally represented presented, or by the written record, or by depositions, or by video conference.
Well, certainly on the
they're
written
represented.
record is easy. We can.
Will you repeat the
Oh, yeah.
question?
Oh, so the question is, for a taxpayer residing outside the United States, how would he or she get his day in court? And one is, and we've had this situation occur in a number of circumstances, and it also really goes to the disabled issue as well, would do everything we could to encourage the taxpayer and the IRS to what we call fully stipulate the case. So that get all of the facts in, get them on paper, and we would sit similar to the way the court in Mexico would sit and not require any witnesses, and the taxpayer would effectively have their day in court on the written record. If there was the need for testimony, we do have an electronic courtroom, and we are able to do video conferencing, and we have used that technique. Now, it would probably take the agreement of the parties to do that if there were credibility issues or other issues that could be, so, you know, but the point is that we would make those accommodations as best that we could.
Same in Canada. And also, we have word process for the judgments for blind people, so they can read the judgment.
Well, I think that concludes, and I want to thank my panelists. It's just been a pleasure working with you all. I was so fortunate to have 3 women on my panel. This has been a joy. Thank you.